Hello, welcome everybody again. My name is Fuji Whittenburg. I'm an attorney here at Wolfstorff Rosenthal LLP, and we practice exclusively in immigration law. I just wanted to quickly introduce myself and then also mention that we'll be going through the different options, and if you have questions, feel free to type them in. I'll try and get back to you. Or you can try emailing me directly. My email and contact information is here. You can also visit our website and sign up for any future webinars. I've been holding these fairly regularly in time, or getting ready for graduation and also the H-1B cap season. So please check the website, and then there are obviously other topics as well. And then lastly, this is pretty much for your information only. Obviously, everybody's circumstances and situation is unique, so please don't, this is not, meant to be direct legal advice for your specific issues, but just, again, for general information purposes only. Okay, so let's get started. Quick, the recent updates, maybe not so recent anymore, paperless I-94 cards. So it's something that they started implementing last May, which at this point should be pretty all the kinks seem to have been ironed out. Every now and again, I think they still have them. Your I-94 card, you no longer receive the white paper I-94 cards at the airport. You still receive them at the at land border ports, of course, Canada or Mexico. But when you're coming in at airports or seaports, it's an electronic. So they'll have your passport, and then you go to the website in red at the bottom of the slide, and you'll be able to access your I-94 information there, and they're basically capturing the flight manifest records from the airlines in terms of getting your information. Okay, CPT and OPT. Before I get started there too, it's always a good idea. I always recommend people check with their international student office. A lot of times your school will have their own workshops for you where they kind of go over how to complete the form and how to request it and what the specific guidelines are. Oh, I got a request to speak more loudly. I will do my best. Thank you. So CPT and OPT, curricular practical training, that's where you're working while you're in school. It has to be a part of the curriculum where you're actually receiving credit for the work. OPT is slightly different. That's optional practical training, and that's normally issued for 1 year after graduation. And during that OPT, your work or training has to be in your major field of study. Should be full-time employment, or it can be, but it can be part-time as well. And then you also have to wait for your EAD card to start working. And you also want to make sure, for those of you who are on OPT now, that you have an updated I-20 and that it's endorsed with your OPT employment, and you'll want to make sure that you update that regularly. There is an option for those of you who are getting a degree in one of the STEM fields, science, technology, engineering, and math. Beyond the 1 year, there's a 17-month extension of the OPT that you can receive. The STEM degree programs are actually listed on the ICE website at the link provided here. So you would want to check. It's nothing that you can really argue. I get this question a lot where somebody says, oh, my degree, I took a lot of classes in science, even though your degree is in the arts or something. There's no wiggle room. Either your degree and then the code, your degree code that's on your I-20 is either on this list or it's not. So that's the first thing. And then also it has to be your the degree on which you have your OPT based on. So even if you have a master's degree in engineering from abroad, again, if you have a bachelor's degree or you're graduating from a bachelor's in finance, and then you have your OPT based on the finance degree, then again, you can't use a prior degree from abroad. So that's something else to note. And then in order to get the STEM extension, the employer for which you're working, they have to be registered with E-Verify, which is a government verification program. And you have to apply while you're in your OPT period, and you can change employers But again, you just want to make sure that new employer is also registered in E-Verify. Unemployment periods, I know that's a very popular question. 90 days of unemployment is the maximum. More than that, then you would be technically considered out of status. How to avoid periods of unemployment? To get, to volunteer or to get an unpaid internship. And you can do that by, interning or volunteering for a minimum of 20 hours, but it has to be in your field of study. So you would want to make sure that you're, working for a company or doing something that's related to your degree. You want to make sure that you're in close contact with your International Student Office so that you can update them regularly in terms of your either employment or unemployment. And another quick note, people always ask, well, how do you, if you don't get paid, how do you keep record of your, internships or volunteering? You would just simply, I would say get a letter from that company or your employers, saying, basically confirming, this is to confirm that, Susie Smith was an unpaid extern with our company from, X date to X date, where she worked, 25 hours a week or something like that, something very, very simple. You do get a 60-day grace period once your OPT ends, or anytime, you change your status, or if it's, anything's, or that application's denied, revoked, withdrawn. So it's good to stay aware of the 60-day grace period. Quick point about OPT, don't forget to apply. The earliest you can file is 90 days prior to your program end date. The latest is 60 days afterwards. You only have that period of time. It's a use it or lose it type of application. You can't, sometimes people have come to me where they're like, oh, I didn't have a job and I didn't. Can I, apply now? You can't. And then another quick point is to make sure that you check with the school about your program end date. The program end date isn't always necessarily the same as your graduation date. So you definitely want to check with the school to be clear on what the deadlines are for filing. And also just to talk about the timing, too, of when you filed, because if you do plan on, I'm going to talk about H-1B next, but if you do plan on filing an H-1B after your OPT, you want to make sure and you want to be aware of the April 1 filing period, where you can't file the H-1B until April 1st. So you want to, for those of you who may graduate in the middle of the year, like December graduation, you want to make sure that you're starting your OPT as late as possible, so you're as close, to that April 1 date or after. The best is to be for the expiration to be after April 1. And then the other point is use it as a stepping stone to find your H-1B employer. Hopefully you'll find a great job. You can work on your OPT, and then 6 months into it or 8 months into it, you'll show them how valuable you are, and hopefully vice versa. You enjoy working there, and then that way, a lot of employers at that point would love to. They'll say, "How can we keep you? What can we do?" So that's another way to look at it as well. Okay, so you graduate, you did your 1 year of OPT, your employer likes you, you like them, and basically now what are your options? Well, probably the main reason you guys are on this call anyways is because of the H-1B visa, which is probably the broadest and most common category for the visa, or for graduates of degrees, would be the H-1B. The job has to be one that requires at least a bachelor's degree in a particular field to perform the job. So, some classic positions are going to be like an accountant or a computer scientist or software engineer, graphic designer. That's what would be a professional occupation. It really does depend not just on the title, but the actual duties. A lot of times, somebody's, let's say, title is project manager, and then their duties are, much more detailed. It's not something that you can really tell until I always ask to look at the detailed list of duties. And likewise, USCIS, when they receive a petition, they tend to look at the job duties, and sometimes they'll say, you know what, you said that this is a software engineer, but looking at the duties, it really looks like this person is a graphic designer or a programmer, something else. So sometimes they'll actually come back and call you out if it's not, if they don't really match up. Anyways, so that's obviously the most important part of the H-1B. A few other quick points. It's employer specific, meaning that you can only work for the employer that sponsors you on that H-1B visa petition. You do need an employer to sponsor you for an H-1B. You can't self-sponsor, and it has to be a U.S. company. It can be part-time or full-time. So you can then, which leads me to my next point, you can apply. You can have concurrent H-1Bs for multiple employers. So you could have 2 part-time jobs, for example, 20 hours with employer A, 20 hours with employer B. Sometimes, that works out for people. There's a 6-year maximum, and it's granted in 3-year increments. But that doesn't mean you have to work for the employer that full 3 years. You could work for them for a year, and then if you change employers, then you would ask for another 3 years, but the total amount of time allowed is 6. It is at-will employment, so even though the employer is sponsoring you for 3 years, they always, usually request 3 years. It doesn't mean that you are tied to them or that they are tied to you necessarily. So they can terminate you at any time, and you can also leave at any time, which, again, brings me to my next point, portability, H-1B portability. That's where you transfer your H-1B from your current employer to a new employer. You actually have to file a new petition when you do that. So I think, we call it a transfer, but I think that's misleading a lot of times because people think that it's just a simple, you write a letter to somebody and you're transferring it, but you actually have to file what we would call a change of employer visa petition, changing from, your current employer to the new one. The good news is you're not subject to the cap again, and you also can start working once the petition's filed, so you don't have to wait for the approval. Okay, so the H-1B quota. What is the quota? It is basically the time of year is when it starts. Would be it's based on the fiscal year from October 1 to September 30th. There's a quota. That means there's a limit or a cap on the number of H-1B visas that they approve and that they give out. There's 65,000 per fiscal year, and there's an additional 20,000 for U.S. graduates with a master's degree or higher. So it has to be a U.S. master's or higher degree to fall into the additional 20,000. How early can you file? The earliest that you can file is April 1st. So that's when the filing period actually opens up. In our office, and in I think a lot of offices, everybody prepares them, they try to at least for March 31st to be sent out on the 31st and delivered to USCIS, whether it's California or Vermont Service Center, on April 1st. Some timing issues, just to give you a brief history for those of you who don't know. Before, from 2003 to 2009, we had, what we would call March Madness, similar to the basketball term, obviously, where everybody would file their petitions, and USCIS would cut them off that first week. They would conduct a computer-generated lottery, and they would select the petitions that they were going to review, and then the ones that were not selected were just rejected. Nobody reviewed them. The fees are still intact, everything. They're literally just rejected. So that's how it used to be. And then, of course, we had the unfortunate, recession where there were high unemployment statistics, and companies were not hiring U.S. workers. They weren't sponsoring foreign workers. So visas were actually a lot more available. And so that year in 2009, although they opened April 1st, the filing period, there were visas available all the way through December. And then the following year, in 2010, they actually stayed, so it was April 2010, stayed open until January, and then, and so on and so on. You can see here, it was the same. 2012, it started to shorten a little bit there, where it opened in April, and then in 2 months they were gone. So last year, on April 5th, USCIS announced that the cap was reached that first week. So it was basically the shortest filing season since 2008, and we were back to the March madness. Signs of a returning economy. Your crystal ball is as good as mine, or my crystal ball is as good as yours, I should say. So I don't know, but based on last year, I do think that the economy is improving. A lot of companies are hiring employees, and they are sponsoring foreign nationals for visas. I know it's a little bittersweet, on the job front, career-wise, obviously that's great, because that means, the economy's picking up and people are hiring. But on the flip side, it does mean that there is a possibility that there will be a lottery, and so when you are filing your H-1B petitions, there is the chance that if there is a lottery, yours may not be selected. So that's something to be aware of. It's not a scare tactic. I don't want to scare anybody or discourage anybody at all, but you should be aware of it so that you can think of backup options if needed. Cap gap extension, we'll talk about that quickly for those of you who are on OPT, and obviously who will be once you graduate. This will obviously apply. Basically, as long as you file the H-1B, obviously during the acceptance period, so after April 1st, but before your OPT expires, there's something called cap gap extension, where your F-1 status is automatically extended and your OPT work authorization is automatically extended. So that way, you would be able to continue working even though your actual card is expired. You can continue to work until until September 30th, and then on October 1st, your status would automatically change over to H-1B. So, a couple things. Obviously, you have to file it as a change of status petition, and it has to be timely filed. If your OPT expiration is March 30th, obviously that won't work because the earliest you can file is April 1st. I mean, it's terrible. You'd miss it by a couple of days. So those are the kinds of things you want to, be aware of and look at. Most people have a, June, July, August expiration date of the OPT. I have a little chart here, I think, that'll illustrate it for you a little bit more easily. So, for those of you who are graduating, let's say this June, your OPT starts, let's say in July. You have the 1 year of OPT from July 2014 to July 2015. So next spring, on April 1st, you would file your H-1B, and then once you file it, your OPT would automatically be extended from your original expiration date in July until September 30th, and then on October 1st, your H-1 would start. So it's really great. I mean, the whole purpose of this was because before we had this cap gap relief, foreign nationals would have to leave after their OPT expired. So usually there'd be like a couple of months at the end of the summer until October 1st, and obviously employers weren't happy either. That's a long time to be be away from your job. So they provided this, and again, you have to very clearly meet those specific requirements in terms of it being timely filed. But for the most part, it is a great way of extending your work authorization. And then once you file, you'll get your H-1B receipt notice. You would take that receipt notice to your school and have your I-20 endorsed also for OPT for a cap extension. Cap gap extension. If for some reason you're not selected, your cap gap relief ends upon rejection, denial, or revocation, and you have a 60-day grace period. So let's say you file on April 1st, and then you're selected, but then in August you get a request for evidence. You respond, and for some unfortunate reason it's denied. Your 60-day, it's denied, and they send you a letter on August 20th. Then you would have your 60-day grace period from the date of notification. They're not going to retroactively, backdate to your OPT expiration or anything like that. It's just from that date. Okay, so a quick overview of the process. The agencies involved are USCIS and Department of Labor. The first couple steps is we're in the middle of doing our H-1Bs right now. So first I'm going to evaluate any, and before I even get there, evaluate any degrees that need to be evaluated if it's based on a foreign degree. So you do that first. Second is just to verify the FEIN, and you have to do that. Once you verify the FEIN, then you can draft the LCA. You can, once the LCA is done, you submit it online. It takes about 1 week to be certified. So this first part, I would say, a lot of people have been asking what's the absolute latest we can, get started on the H-1B. Because of the LCA, the FEIN, and having the 1 week to be certified, I would, budget in, about 2 weeks, and that's if everything runs really smoothly. If for some reason the LCA is denied because of a glitch, you clicked $35 per, hour rather than $35,000 per year, or something like that, then your LCA could be rejected, and then you'd have to file a new one, which would take another 7 days. So I would factor in about 14 days. 2 weeks is the safest, and during that time you can basically prepare and file everything else. Once you have that, the second step is USCIS. You basically prepare the job offer and the forms, company information, filing fee checks, LCA, everything. You submit it to USCIS. Some common issues, and I write here RFE issues, and RFE is a request for evidence. They do love to ask about the specialty occupation of the job or of the position. They want to make sure that it is a specialty occupation, that the degree is related to the occupation, that a degree is actually required, things like that. And that's super common. So if you get an RFE, don't be alarmed. It's just, again, a popular point to question. And then VIBE is another thing here. That's where it's the government's own. It's basically a business verification instrument that they use where they want to match up the company name and information and tax ID number, so like the address and everything. So they actually look it up and they check it online. So that's something that you want to make sure that is updated with Dun & Bradstreet. Overview of the H-1B, there's a 6-year maximum, which I had mentioned before. You can have H-1B extension, so once you file, you don't have to worry about the cap again as long as you're selected. So in like 3 years, you don't have to, think about, the cap in April 1 and all of that. So that's the good news. The H-1B remainder option, it's if you previously, some of you maybe who are listening, you had an H-1B, 5 years ago, and then let's say you had your bachelor's degree, did an H-1B for a couple years, decided to go back to school to get your master's degree or an MBA or something, and now you're on your OPT, you can actually basically use whatever you didn't use last time in your H-1B. So if you use 2 years, you would still have about 4 that you could use, or if you wanted to, get the whole 6 again, you could, file under the cap. And then if you've been, another thing you can do is if you've been physically outside for more than 1 year, again, you can recapture the unused time, or you can file for a new 6 years under the cap. Startup businesses, a very popular question as well. Obviously, with the H-1B, the job position is really important, what exactly you'll be doing, and then also the viability of the company is important as well. But you can have H-1Bs with startups because, we've definitely done it. The company should be able to show they have this financial ability to pay your salary as well as all overhead costs. So it's the, the lease, the power, the phone, the internet. There are lots of other expenses that go into running a business. But in addition to that, to be able to show that they can pay, other people's salaries as well as yours. And usually I do that, with bank statements, or if, the company is getting some serious investors involved, where, if you can show the investment and the business plan. Those are all the types of things you'd want to show to kind of build up the viability of the company. In terms of what you'll be doing, we would need to show in the petition that it's a real position and it's a professional job that requires the services of somebody with a degree, and that's something that you would be able to provide. And then there should be an actual business office or a place of work. The company has to have a tax ID number. It can be owned by the H-1B employee, but, and there's a huge but here, it really would have to, the company would have to be wholly separate, from the owner or the employee. It would have to be a true, the corporate entity is separate from the employee, and that there's an independent board of directors to show that the employee doesn't have control over the company, and actually the decisions are made by the board. So it's very difficult to show, but there is a way to do it if you are actually the owner, because otherwise you can't self-sponsor, and it's very tricky and very difficult. So I have to say that, but it is, again, if it's legitimate, you can do it. I will say that if you're doing a startup, the business plan with financial projections is very important. I think in building a strong case, that when you're presenting it to USCIS, you really want to convince the officer that, again, it's a viable company, your wage will be paid, and that the position is going to be professional. Because, with startups, I think a lot of people understand where, everybody wears a lot of different hats. Everybody kind of has to pitch in because it's a startup. You're putting in a little bit of time, and, you're answering phones, or you're preparing the FedExes. You're doing a lot of admin work with the understanding of, that you're, at the start of hopefully what's going to be a very successful company. So those are the little things that USCIS could pick on. So you really want to make sure that you're performing a professional job, and then again, that what you're doing is related to your degree. So if you have a degree in, let's see, for example, engineering, but you are the CEO of a company that, is selling a non-engineering product, for example, that doesn't really make sense. Your CEO position should be backed up with a business degree. I mean, I would think, and USCIS is going to think the same. Anyways, I could go on, but that's, generally for your information here, it is a possibility. You just want to be careful of those little issues. In terms of employer obligations, I still, just last night I was speaking at a local college, and I got this question where the employer said that they had to pay the government a fee just to sponsor someone on an H-1B, and that they had to show that there are no other U.S. workers. So that's not true. Those things may apply in different ways to other types of cases, but for employer obligations, they have to pay you the prevailing wage, which is found at that link, and that's, we actually have to look up and file the H-1B with your prevailing wage, and there can't be any benching, so they can't say that, oh, this is a slow period, don't worry, you don't have to come to work, and we're not going to pay you. Maternity leave is okay in terms of not, coming to work for a long period, or if you say, you know what, I want to go home to, India to see my family for 1 month, can I take a leave of absence? That's okay because that's voluntary, but they can't impose that on you. In terms of termination, they have to, the obligations they have are to notify USCIS and withdraw the LCA, and they have to also offer a reasonable cost of transportation home. So they, they just have to make the offer. Whether or not you accept it is up to you, but they are required to make the offer. So these are kind of very, broadly, these are the main obligations that an employer that is sponsoring you has. So it's also something to be aware of. Portability we touched upon earlier. Again, you can transfer your H-1B to a new employer at any time. You won't be subject to the cap again because you've already been counted. And again, you can start with the new job as soon as you file. Who's responsible for the fees? Hopefully, the owner will pay all of the fees. I really hope that for everybody, and always, push for that. But, realistically, that's not always how it happens. But there's, or how, people want it to happen, but it almost has to in a lot of situations. You have to be paid the prevailing wage, which we mentioned earlier. So if you're paying any portion of the fees, then whatever that amount is that you're paying actually brings you down below the prevailing wage, which I know sounds kind of crazy because it's not like, you say, well, what if I want, if you want to buy an airplane ticket or take a trip, those things don't bring you below. But this, because it's tied to your visa, the whole process, it actually is factored in. I have an example here. So let's say your prevailing wage. We look it up on the Department of Labor website. It's, you're an accountant in Los Angeles. We look it up, and this isn't accurate, but it may, accountants in Los Angeles make $60,000. Prevailing wage is $60. You're getting paid $60. Perfect. I'm happy. You're happy. But if you pay for any of the fees, your salary would drop below the prevailing wage. Who will know? I make a sad face here. I don't know how it'll come up, but it can come up. I mean, there are work site visits and audits where agents, I get clients who call me, corporate clients who call me and say, oh, I just had ICE stop by today, and they asked to speak with me, they asked to speak with the employee, they asked to look at payroll records, so that's a possibility. It can also come up at the visa interview. Down the line, the H-1B visa interview, they can ask to see your pay stubs, or if it's, they could say, oh, let me see your W-2 for last year to make sure you're getting paid the right wage. So it's something to consider. But let's say you are, you're like, oh, prevailing wage is $60. I'm getting paid $80. I can pay for everything, right? No. In terms of guidelines or guidance from the Department of Labor, the employer has to pay the fraud fee and the training fee. So there are three fees essentially. There's a $325 government filing fee, $500 fraud fee, and then the third fee is the Acquia training fee, which is either $750 if it's less than 25 employees, and then $1,500 if it's more. So of those fees, the employer should, really pay all of them. You could possibly pay the I-129 fee or the premium processing fee if you would like to, and you're getting paid above the prevailing wage. Again, it's something that should be looked at on a case-by-case basis, but it's something that is, very tricky, but also it's very closely looked at. And another quick point is no reimbursements, too. You can't say, oh, employer, you go ahead and pay, and then you can, dock my paycheck, or I'll pay you back later, or my mom will, pay you or send you a check. Nothing like that. No funny business, I guess, is the point. So the prevailing wage, just make sure we look at that. And at the start of every case, again, before we move on, I look at the prevailing wage because if your employer can't pay you what that is, then we can't really file the H-1B petition. Somebody just asked, what is the prevailing wage? It's the wage that Department of Labor, they do a survey of, your particular metropolitan area and what people in that field are getting paid. And there's a level 1, 2, 3, 4. Level 1 is the entry-level wage. And so literally I just would look up what does a graphic designer in Los Angeles make. There are just different fields you choose, and it'll come up level 1, 39,420, whatever it is. And so that's what, we would have to go by as the prevailing wage. You can also make a prevailing wage request with the Department of Labor, too, based on a specific job. So anyways, that's a pretty integral part of the H-1B. Like I mentioned earlier, audits and enforcement, there has been an increase, a steady increase, I would say, in fraud investigations and unannounced work site visits where they just show up. They want to make sure you're not, you're doing what we said you were doing in the petition. You're not really there. We said you're a computer software engineer, and you're answering phones. That's the kind of thing they'll show up and say, oh, where does so-and-so work, or where do they sit? And they'll come and look, and they'll talk to you, and then they can ask to speak with your HR or your supervisor and to look at payroll records and, about what you do. And then, again, they want to make sure you're being paid the prevailing wage. So H-1B visa holders or dependents would come in or be given H-4 status for spouses and children. There's no employment authorization, unfortunately, for spouses, but everybody can go to school. So your spouse or child obviously could go to school. If your spouse would want to work, they have to apply for their own visa. What happens when you reach 6 years? Is 6 years really 6 years? Yes, for the most part, with a few exceptions. And this is a good point to make, again, as you guys start out your careers, once you do the H-1B, any time that you spend abroad, whether it's for business or it's, for pleasure, your own personal trips, and then whether you go home to your, home country or even just to somewhere, I don't know, like Canada or France or wherever it is you're going, any time spent abroad, you can actually recapture, which may not sound like a lot, but at the end of 6 years, believe me, I mean, I've had clients who've recaptured, a year and a half of time, where it's like 2 months here, 3 months here. It really adds up, especially if you travel a lot for business. So it's something to really keep in mind or keep track of over the 6 years, because if you try and do it at the end, it's not the most pleasant experience to have to look back. Another way to extend beyond 6 years is if you have, if you're in the green card process, you're at certain points in the green card process. So if your labor cert's pending for more than 1 year, you can extend for in 1 year increments. Or if your I-140 is approved and you can't file because of backlogs, then you can extend in 3-year increments, which is nice. And that's really what a lot of people who have been waiting a long time is what they do, because you want to make sure that you're maintaining your underlying status while your green card application is pending. If you haven't filed your adjustment of status application, you're not going to have any work authorization. So you're still going to want to continue with some work authorization visa in order to continue to work and be here. Some myths about the H-1B visa. You can do an H-1B for a small company or a startup. We went over that in the beginning. You don't have to advertise for the H-1B position. That's not a requirement to show that. That's a requirement in the PERM green card process. So that's something worth noting. You can change employers if the cap has been met. You don't get a new 6 years every time you change employers. It's just one time 6 years. Another common, I think, myth or mistake is that there's this like 10-day grace period after a layoff. Unfortunately, if you're laid off, your status terminates immediately. Hopefully your employer would give you notice to give you opportunity to find another job or to figure something else out. But if not, I just want you guys to remember that there is no grace period. So you want to be very mindful of that. You can go to school part-time on an H-1B. So if anybody wants to go to night school to get a master's degree or something like that, you can. And then is it okay to file under, so you can't file under the master's cap before you complete your degree. No, you can't. You have to have finished all degree requirements when filing under the quota. So if it's a bachelor's degree, you would want to, you have to make sure that you've completed the degree in order to file. So April 1st, a lot of times people haven't graduated yet from, whatever their degree is. You would have to wait till the following year. So if you have a master's degree that you're graduating with in May, on April 1st, you're not going to meet those requirements. Probably your program hasn't ended at that point, but maybe you finished everything in December and you're just walking or graduating in the spring. And so in that case, I would get a letter from the registrar showing that you've completed all degree requirements and that you're just waiting to graduate in the spring. And then if you have that, then you can file. Otherwise, you would have to just use a previous degree, and you would just go under the bachelor's cap. Premium processing does not increase the chances of approval. I think a lot of people think that if you pay the extra fee, that it somehow legitimizes your petition, or that it, again, increases. I don't really play, those games, filing this way or that way. I think, we all have our guesses, but we definitely all have our ideas, I think. I will say that last year when I filed under the cap, all of my cases I filed under premium processing. It was by chance. It wasn't even that I pushed. I think everybody just wanted to know for peace of mind, and they were all selected. But I don't necessarily think that means anything. I'm just sharing that with you. But again, it doesn't increase the chances of approval. And then, the last couple points, no one will check. Yes, somebody will check, I think, at some point, So you want to, again, you have a lot at stake. So I would just, you want to be on the up and up and be careful. Even if your employer is like, oh, nobody will know, it's okay, we've done this before in the past. I hear that a lot. You have to have a U.S. degree to qualify. That's actually not true either. Foreign degrees are okay. They just have to be evaluated and found to be the equivalent of a U.S. bachelor's or higher. So that's something else that you should be aware of. Okay, so let's say, unfortunately, or let's say, you file under the cap on April 1st, and everything's in order. The petition was great, but then we find out the cap was met, and then, either so let's say the petition was rejected and you weren't selected in the lottery. You have to think of another option. Or let's say you try to get everything in, but you're basically too late. What are your options at that point? Well, you have a lot of options, actually. There is an H-1B for cap-exempt organizations. So what I talked about probably the first, this first part was for cap-subject organizations. So all private companies and employers are cap-subject. Some organizations are not subject to the cap, and that means that they can, file for you at any time. And they include institutes of higher education, so universities and colleges, nonprofit organizations affiliated with these institutes of higher education. So a lot of times, like hospitals are affiliated with universities, things like that. A nonprofit research organization. Again, note research organization. It's not just like any nonprofit organization or a government research organization. They're very clear about what these specific designations are. I think the company that is sponsoring you would know if they're designated as any of these or under any of these categories. Usually they have some sort of tax exempt, status as well. So it's something you would have to check. But that could be an option for those of you who would want to work, let's say at a university or something. That way it would give you some more flexibility. But let's say you want to work at a university and then in a few years you want to switch back to private industry, then at that point you would be subject to the cap. Okay, so another option, free trade agreement visas. These all require a professional occupation and degree, just like the H-1B petition, but they have slightly different rules and filing requirements, and processing is a little bit different. You have H-1B ones for Chileans and Singaporeans. That would require you, basically they can apply directly at the consulate, so it's a little bit different, and they're, the filing requirements are different, and the filing fees are actually a lot less when you're filing at the consulate. There's a TN NAFTA visa for Canadians and Mexicans. You can check the TN appendix for there's a specific list of occupations, so that's where it's a little bit different from the H-1B. but Canadians can apply at the port of entry, so they would just, you prepare the application, and Canadians, you would just present it at pre-flight inspection, let's say, at the Vancouver airport, or if you're driving across, in Buffalo or something like that, you present it there, and you're adjudicated on the spot. Mexican nationals, you would prepare the application, and you would actually take it and physically apply for the visa at the U.S. Embassy in Mexico. It's pretty quick. Now, of course, they have the biometrics, the fingerprinting, before you have your visa appointment. It's usually like a couple of days beforehand. But again, it's quick, and you don't have to pay all of the government filing fees, and you don't have to wait for processing times because, again, they're adjudicated on the spot. Similarly, there's an E3 visa for Australian professionals. Same thing, where you put the application together. We prepare it, give it to the foreign national, and they apply directly at the U.S. consulate in Sydney. And if they've had one before, they don't have to go to the consulate in Sydney. You can either file to extend it in the U.S., just like TNs, you can do the same. Or for E3s, you could go to the consulate in Canada or, somewhere else if that's closer, if you've already had an E3 before. Some other options, this wouldn't apply for those of you listening who are international students, in the U.S. currently, because you either have a U.S. degree or you will have one. Typically, J1s are for people who are, I have listed here, you have a degree from a foreign institution, or you have work experience outside of the U.S. So really, it doesn't apply to a lot of people, or unless you can, let's say you got a U.S. degree and then you return back to your home country for, a couple of years or something like that, then you could apply for a J1. So I'm just going to skip ahead, but it's for trainees, interns. And then you can also get a J1 for teachers, and then also professors and research scholars as well. Something to note quickly for the J1, in case anybody ever is interested or offered one, there is for some people, there's a 2-year home residency requirement, meaning, once you finish, you have to return home for 2 years before coming back before you come back to the U.S. You have to do that. You can get a waiver of this requirement, and again, not everyone is subject. It'll be stated very clearly on your J1 visa or on the DS 2019. Somebody just asked, what about the cultural exchange part of the J1? Again, they have that would be for the trainees and interns, and that would, there are very specific requirements that you would need to show, that you're coming from abroad. There's an H3 training program not available in the home country, and that it will benefit your career abroad. That's something that you would have to show. You also have to show that there's no productive employment and that it's all incidental to training. So the J1 and the H3 are very focused on training, and that you're, it's not really work or employment, that it's your, again, learning. And for the J1, yes, cultural exchange, where you're kind of learning a little bit about, the American economy or the American market, and then you would be going back to your home country. And again, with the H3, same thing, that you're coming here to learn, train, and then take those skills back to your home country. Similar to the F-1, just so you're coming here to study and then, return home once it's finished. Things change, obviously. So some other options, there's the L1A and an L1B visa. This is, really for multinational organizations. You have to show that you've worked for 1 year abroad at the parent, affiliate, or subsidiary as an executive manager or specialized knowledge individual. This would be good if, time-wise, I don't know how it would work for a lot of you who've been here in school for, 4 years. It wouldn't work because it has to be 1 year in the immediately preceding 3 years. But let's say you get a job offer now for, working at, a large company, KPMG or something abroad. They don't have a job for you here, but they have a job, in their Buenos Aires office. you could go and work there for a few years or 1 year at the very least, and then if things go well, they could always transfer you into the U.S., and that's where they would use this visa for that purpose. So it's really based on the corporate relationship, so there has to be, multiple offices of the organization, abroad, whatever the corporate relationship is, they would be transferring you from abroad into the U.S. And then you have to have that experience, at least 1 year with the company abroad before coming into the U.S. You can be a national of any country. It's not specific to any countries at all. There's no quota. And then in terms of the length of the visa, the maximum is 7 years. If there's a company abroad that you worked for and they want to send you into the U.S. to do the, they want to send you into the U.S. to set up a new office, they'll only give it to you for 1 year, and at the end of the 1 year, you would have to demonstrate that the company's up and running, you've hired employees, and things are going well, and then they'll extend it, and then you can extend it a couple more times, but the maximum being 7 years. Startup issues, again, the place of business, having an actual office lease and an office space, hiring employees, having the investment and the funding behind it. So a lot of times if there's a strong company abroad backing it, that's always very beneficial and helpful for the application. And then also showing the need to transfer you over as the manager or executive. That's something else that has to be demonstrated. And the business plan, you should always have a good, strong business plan with financial projections for a new office L1, if that's something you're thinking about. Again, it's only good for 1 year, that new office L1, but again, it's a good option for a startup. And spouses and children receive the L2 visa, and spouses can apply for a work permit, which is really nice, and it's unrestricted, and it's a good basis for the EB-13 green card. So that's the L visa. The next category, the E visas, E1, E2, treaty trade, and treaty investor visas. That's for those of you who are listening who you're like, you know what, the H-1B is not for me. I want to have my own company. I'm an entrepreneur for business savvy people. Then this is a great option. But first, before getting too excited, you have to make sure that you're eligible. So there has to be a treaty between the U.S. and your home country. And I've written here, check the treaty country list at travel.state.gov. So you can go ahead and check to make sure that you're on there. If you are, then this could be an option, again, if you're interested in either buying a company that's already in existence or you want to start up your own company, then this is great. You have to show at least half of the company is owned by yourself or someone, by the treaty country. Treaty trade, that visa that you want is mostly for people who are interested in import-export. You have to show the trade between the country, your home country and the U.S. The E2, you have to make a substantial investment. Everyone always asks, how much do I need? They just call it a substantial investment. So, we've generally seen, I would say, $100,000 to $150,000. That's not just money sitting in a bank account. It's money that's actually invested into the company. They want to see that it's been placed at risk, meaning that it's been spent. So you have purchased equipment or inventory. You've spent money on a lease. You have a sign. Let's say we'll use a restaurant as an example. That's the easiest way to illustrate this. You're setting up a restaurant. You bought the tables and the chairs and the equipment and the plates and the menus. All of those things have already been purchased. And then your position would be either to direct and manage the business enterprise as an executive, or to kind of be a manager or to be an employee. It kind of depends on what it would be. But as the investor, it's really to kind of oversee it broadly. Spouses and children receive dependent visas. Almost all visa categories, I think I can say all of them, will get a dependent visa. Whether or not they have work authorization is very limited. So just like the L visa, spouses on the E visa also receive a work permit, or they can apply for it. You don't receive it automatically. You have to apply. But it's great because it's unrestricted. It's not limited just to this company or, you know, to, well, yeah, it's not limited to the company. You can work anywhere you want, even though your spouse has the company visa. O visas is for aliens of extraordinary ability. The classifications, there's an O1A and an O1, basically the O1B category. O1B is split up into arts and motion picture TV. This visa category really is for, you know, again, if you're more in the arts, this could be a good option, or if you're in, you know, kind of science, business, education, you could try the O1A as well. This is for people who are pretty established in their careers, and the H-1B kind of restrictions don't really fit with your career and your credentials, and the O visa is a really good option. O2 is for essential support, and that's only for motion picture. That's for the arts and motion picture TV. O3 visas is for dependents, and this is one of the categories that does not have work authorization. I'll quickly run through the visa standards again for the O1. This is, you know, this is going to be maybe further down in your career, or maybe you've experienced or enjoyed some success in your career abroad before coming to the U.S. For a degree. But as you can see, you know, you have to show you're very at the top of your field. You're one of a small percentage who's risen to the top, high level of achievement. And these are the standards that we have. In terms of the criteria and types of evidence, it's going to be awards, press, memberships, you know, original contributions. So let's say, you know, patents or original works, or if you are a writer and you've written a book, you know, those kinds of things, authorships. If you present at conferences, if you've been invited to serve as a, you know, a guest judge on a panel, earning high salary, getting reference letters from people in the industry, and then, you know, for some of the more arts entertainment, you know, it's going to be the press, the, you know, IMDb printouts and things like that. In terms of, you know, your job search, okay, I think that's pretty much all the visas that I was going to review. Job search, I mean, I've listed some things here. I think it's always good to ask around as much as possible and keep your options open. And, you know, network. I think everybody's really, you know, into networking. You never know where your next opportunity is going to come along. And, you know, something to focus on would be your international perspective. I think, you know, it's a hard situation. I know applying for jobs and getting jobs is difficult, but you do have, I think, something that you can focus on, and cultural diversity is really important in a global economy. That's what I would say. And then obviously, you know, you have your academic credentials backing you up, of course, but that's something to keep in mind. Moving forward to the green card, there are, you know, several ways to get a green card. Let's say, you know, everybody goes through, you do your OPT, you do your H-1B, you're in your H-1B period during the 6th year, somewhere around, you know, 3rd or 4th year, and you're starting to think, oh, how am I going to, you know, I love it here, I want to stay longer, and likewise your employer is saying, I want to keep you, like I want you to stay, what can we do to keep you? There are a few options. First, there is a green card lottery, which is totally separate from your employment. It's just diversity. It's called a diversity visa green card lottery, DV lottery. Travel.state.gov, every year they give away 50,000 green cards. I don't know how much longer this program is going to be in existence, so if you are eligible, it is one of those programs where it's based on country of birth, and you have to be eligible in order to participate. So like the E-visa, before you get your hopes up, you should definitely check the list, and I have it actually on my next slide. It's open every year, October to November, and it's a 1-month period where you can file. You don't have to pay anybody anything. You can do it yourself. If you want somebody to take care of it, obviously you can, but I just wanted you to know that it's not something you have to pay for, and it's a fairly simple form. It is based on country of birth, not your citizenship. And then I've listed here the countries. I think this is the most updated list. I would have to double check, but as you can see, the immigrants from these countries are not eligible based on the amount of people from those countries who are presently living in the U.S. You can cross-charge to your spouse's country of birth, meaning if your spouse is eligible and you're not, you can still file under your spouse. Okay, so that's green card lottery. If you're eligible, please do it. People win all the time. Second option, family-based green cards. And there are different categories. The first category, quickest category, is going to be immediate relatives of U.S. citizens. An immediate relative is a spouse, parent, or minor child. So adult children, if you're an adult and your parent, your mom or dad is a U.S. citizen, you wouldn't fall under this processing category. In this category, you get immediate benefits. You get a work permit and travel document within 2 to 3 months. It's a pretty quick processing period. I would say about 6 months. 8 is a little long right now. It's about 6. If you are filing based on marriage to a U.S. citizen, so let's say you're dating somebody and they're a U.S. citizen. Life happens. You may get married. You would file this. You would get a 2-year conditional green card if you've been married for less than 2 years. So that's something to keep in mind. And then after that, you would remove the conditions. And then another really common question is, oh, I have a child who's 2 years old, born here in the U.S. Can they sponsor me? No, that child has to be 21 years old in order to sponsor you. So you'd have to wait a while. And obviously last summer, there was a repeal of DOMA. Yay, it was great. Great news for everybody. And that's where same-sex couples are now eligible for immediate benefits. So we're filing a lot of those cases in our office as well. Family-based green cards, a few more. So I've listed here a few more of the categories. Unmarried adult children of U.S. citizens. There's a 7-year backlog. Spouse, child of LPRs. That backlog changes. I think right now it's probably maybe like 1.5 years or something like that. And they switch around. You can see they're much longer, and then the longest being brothers and sisters of U.S. citizens. And there's a 12-year backlog on that. You can check, and this is updated monthly. You would check the visa bulletin at travel.state.gov for the most recent visa bulletin and dates. But this should give you an idea of how long it is. I like to equate this to, and just like this is the same for employment-based, which I'm going to next, but it's kind of similar to getting a ticket to go to the movies, where you just kind of have to stand in line, and the sooner you get your ticket, the sooner you get called in. But if you're just standing outside and you never get a ticket, then you're never going to get to go inside. I don't know if that's too much for you guys, but it's just a good idea to get started as soon as you can, if you do ultimately want a green card. Okay, so that was family-based. Now let's switch to employment-based green cards. There's EB1 through EB5. EB is employment-based. So we'll start with EB1, first preference. This is the kind of the top of the top, the elite category, similar to the O1. Extraordinary ability type people. There's EB11, EB12, EB13, but all fall under first preference. And again, these are for your, celebrities, your Nobel Prize winners, your scientists, your, entrepreneurs who have, set up these, successful businesses, things like that. They have higher standards of proof and evidence, but they also have faster processing and wait time. So that's the EB1 category. I hope, at some point you're able to qualify there. If not, there's still 2 others, EB2 and EB3. These 2 are probably the most common. Like the H-1B, visa is very common, kind of is the, catch-all for most people. EB2 and EB3 is where a lot of you will stand too. This is where the employer would file. It requires employer sponsorship. All of these, except for the national interest waiver, the NIW, require employer sponsorship, so that's something important to note. And under PERM, PERM is the name for the labor certification process that we just call it PERM, that we would file for you, or obviously the employer would be sponsoring you for. And in order to fall under EB2, which is a higher, which is just kind of a faster processing time, the job has to require somebody with a master's degree or higher, or a bachelor's plus 5 years. So that's where it's all about the job, not about you. And then there's a Sched A Group 2 for exceptional ability. That's another way to fall under EB2. And then there's the NIW, showing national interest waiver that you're doing, you're working in an area of national interest to the U.S. EB3 is third preference, and that's just a slower category, but still one that would apply to most people, where the PERM job offer you can show is being offered, and the position is for somebody with a bachelor's degree or the equivalent, or it's for skilled workers or other workers. So that's the two main categories for the PERM. Step 1, the PERM labor certification process. This is all very technical, so I'm just giving this to you for your information. Step 1 is the PERM. This is where the employer conducts the good faith recruitment. They post Sunday ads. They do the employee referral bonus. They put it on Monster and all of that. They advertise literally for your job. Once that's done, they show there are no qualified U.S. workers. That's certified. Then you go to step 2. You file the immigrant visa petition, the I-140. That's where the employer has to show the ability to pay. A lot of times it's, for the most part, they're going to have to show their tax returns at that second step to show they can pay your wage. And then the third step is the adjustment of status. So where most people get stuck is between steps 2 and 3. If your category or if your priority date is current within the classification, then you can file steps 2 and 3 at the same time. And you can only do it once your priority date is current. If your priority date is not current and it's backlogged, then you can't file step 3. You can file step 2, but not step 3. Step 3 is what gives you that. There's a work and travel authorization card that looks a lot like, it's almost identical to your OPT card, and that's what would give you some sort of independent work authorization from your H-1B. So that's where most people want to get, and you hear about backlogs and things like that. I've put here, up here, the March 2014 visa bulletin from the travel.state.gov website for the employment-based categories. As you can see on the left-hand column, it says employment-based, first, second, third, other workers, fourth. And then across the top are the different countries of chargeability. So EB1, C means current. So everybody's current in the EB1 category. EB2, everybody except for China and India are current. And then in EB3, there's this, backlog of, not too bad. It looks like about 1.5 years for most countries. Obviously, and then it's slightly longer for India. It's much longer, actually. It looks like it's like 11 years. And Philippines is, I'm testing my math right now. It's, a little under 7 years. So this is what you would want to check to see what the current processing times are. Like I said, this is updated every month, so it changes all of the time, but it's something that you would want to be able to look at in terms of determining the timeline of your green card. Deciding between the two, I don't want to, go too much into it, but it's not based on your background, but the actual minimum requirements for the job. So if your employer says, I only, somebody with a bachelor's is required for this job, and you have a master's, you're like, great, we can file under AB2. Well, if the employer is saying that only, you only need a bachelor's degree, then it's going to be EB3. You can't, tricks that don't work, you can't tailor the requirements to your experience in education. A lot of these things would be red flags. Having a foreign language requirement, that would be a little bit of a red flag, unless it's actually, it's a translation company or something where it's an actual, function of the job, not just, oh, we have a lot of Chinese clients, so we want the person to speak Chinese. It becomes really difficult, and you have to show that it's, a business necessity. When to start the green card, I would say usually around the 4th year of being in your H-1B. You want to make sure you like the employer and vice versa. A couple of other green card options. There's a religious worker visa option for a green card, EB4, and then EB5 is the $1 million. That's for the investors. There's a $1 million investment or $500,000, where you basically, put in, you invest, and depending on which program you use, $1 million, or you could do a regional center, where it's, the regional center is more of a pre-approved program, so it's a pooled and passive investment. And then the $1 million investor is more if you want to start your own company and you have to show you can create 10 full-time jobs, and obviously there are a lot of criteria that have to be met, but it's a great option if you have the capital, obviously, or if you have some, friendly, generous relatives. Okay, so that concludes the slides. Here we go. We're done with the green card. Thank you so much for registering and for listening in. If you have any follow-up questions, please feel free to email me. My email address is listed here. It is in the middle of H-1B cap season, so if you can, be understanding that if it takes me a few days, I will get back to you as soon as I can. And feel free to, follow us on Twitter, like us on Facebook. You can sign up for our newsletter and check our website regularly for updates. We do have these webinars very regularly. And good luck. Thank you so much.